We are breaking down the shocking development in the case of the California dermatologist accused of poisoning her husband with liquid drain cleaner. A court just threw out the case for now. I'm going to get into the history. I'm going to get into the legal reasoning. I'm going to give my opinion because this decision, in my view, presents a much larger issue in the cases that we follow. Let's talk about it. Welcome to Sidebar, presented by Law and Crime. I'm Jesse Weber. All right, before we jump into this, I got to tell you about this app, this sponsor, this partner. I think you're going to love it. It is called Upside. Now, Upside gets you cash back. That's right, extra cash back on everyday purchases like gas, groceries, takeout. Here's what you do. You download Upside for free. You claim an offer at one of their 100,000 plus locations. You pay like normal with your card. You verify the purchase, and just like that, money back. So say I need to get gas or I want takeout one night, I'll search for Upside offers first, and after I spend, money appears in my app that I can transfer right into my bank account. And Upside's frequent users, they earn an average of $254 back a year. So to start getting your cash back, click the link in the description or scan the QR code, but make sure to use promo code SIDEBAR to get an extra 25 cents bonus on every gallon on your first tank of gas. Why did a court throw out the felony charges against a California dermatologist accused of poisoning her husband's drink, his tea, lemonade, with drain cleaner, especially when there was an alleged video of her doing this? Seems like a pretty strong case just in the outset when I say that, right? Seems like a pretty strong case to send to a jury, right? Maybe, maybe not, but I'm going to break down the why, because it has bigger implications than just this case. When I go through why it has been dismissed for now, this reflects something that I've talked about before, something very important in how we cover these cases. And especially in the cases where the evidence may appear or can be argued to be quite strong. Gotta follow the process, gotta follow the procedure. Make sure you grant a criminal defendant every right they are entitled to. Otherwise, the charges can get thrown out. The conviction can be overturned. Now, as you're also going to see, there's a little bit of a dispute as to what happened here. A lot of moving layers, a lot of moving pieces. I want to get into it. So let me explain why it's so important. Let me explain what happened, but I got to go before this, right? I got to give you context. I got to give you background. Back on April 5th, 2023, an Orange County grand jury indicted then 45-year-old Emily Yu on charges of poisoning and domestic battery with corporal injury. She had pleaded not guilty. The charges had stemmed from allegations that over the course of several weeks, she allegedly had been tainting her husband, radiologist Jack Chen's beverages, tea, lemonade, with liquid drain cleaner, and that this resulted in him suffering stomach ulcers. She was facing up to 8 years and 8 months if convicted back on those charges. You're going to see a little bit of a change there. Now, according to the Orange County DA's office, back in April of 2022, Yu's husband started noticing that there was this strange taste to his tea, which apparently he would drink daily. And according to CNN, in court documents, Chen had alleged, quote, "I started noticing a chemical taste in my lemonade. Eventually, I developed symptoms that had me see the doctor, who performed an examination and diagnosed me with 2 stomach ulcers, gastritis, and esophagitis." So what did he do? He reportedly sets up cameras in the kitchen area to find out what's going on. And according to investigators, on July 11th, July 18th, and July 25th, 2022, so 3 separate alleged incidents, video reportedly shows his wife pouring a substance out of a liquid drain cleaner bottle into Mr. Chen's tea or drink on the counter. Now, according to CNN, Chen claimed that he noticed in a video that his hot lemonade was covered with plastic wrap, and that the video allegedly shows her, quote, taking the Drano from under the sink, removing the covering to pour the Drano, and then replacing the cellophane and putting the Drano back. The husband then allegedly collects the samples of this drink, of the tea, of the lemonade, and gave them to the Irvine Police Department. And the samples were then reportedly sent over to the FBI for official testing. And according to the DA's office, those samples, according to the FBI, turned out to be liquid drain cleaner. So what happens? Yu was arrested in August of 2022. At the time, Orange County DA Todd Spitzer released a statement. It said, quote, "Our home should be where we feel the safest. Yet, a licensed medical professional capitalized on her husband's daily rituals to torment her husband by systematically plying his tea with a Drano-like substance intending to cause him pain and suffering. Thank you to the Irvine Police Department for its diligence in thoroughly investigating this case, and to Deputy District Attorney Diana King for her conscientious legal review that allowed the case to be successfully presented to the grand jury for an indictment. So it's interesting because I'm sure the argument would be she knew his schedule, she knew, when they say ritual, she knew what he liked to drink, when he drank it, right? That would go into the prosecution's argument. At the time, the police said Chen, quote, sustained significant internal injuries but is expected to recover. By the way, apparently you, the defendant here, still maintains an active medical license out in California, and according to the Daily Journal, she performs micrographic surgery on skin cancer patients. Her defense says she's a very esteemed, renowned dermatologist. So now the question would be, why would she allegedly do this, right? According to Court TV and ABC News, in an application for a restraining order between the couple because Chen had claimed that you and her mother were abusive, and the couple apparently have 2 children together. Chen was seeking sole custody. In this application, he apparently wrote, quote, not only was she very demanding of me that I give her massages, one time when I could not because I was sick, she stepped on my head until I did, and also began hiding money from me. Yu's attorneys have fought back against this. They have fought back against this narrative. They claim that she's innocent, that she never tried to harm her husband, that this all stems from a bitter, bad divorce between the couple, that Chen had allegedly orchestrated all of these claims, these allegations, quote, in a deliberate attempt to gain advantage in family court proceedings. The strategy succeeded in the most painful dimension. Due to the charges, our client has been separated from her children for years, end quote. Now, what's the defense, right? You see it on video, right? What's the defense? Well, this is interesting. According to the New York Post and CNN, Yu's defense team claimed, wait a second, she was just pouring this liquid cleaner to kill the ants in the kitchen. That the family would mix the Drano with lemonade, the tea, to do so. Lure them in, kill them. And that Chen, you know, the injuries that he allegedly suffered, that he was suffering from acid reflux, not poisoning. CNN reports that Yu's defense team even claimed that Chen never went to the emergency room. So her defense attorney, Scott Simmons, said he's falsely claiming that she's trying to poison him. Instead of calling 911, he calls a divorce lawyer. Simmons said in 2023, it's our opinion that the medical evidence is inconsistent with his claim that he consumed the Drano. As you know, Drano is a caustic substance. You would have severe injuries from consuming the Drano. The injuries that he claims are from the Drano, we think the evidence will show that is consistent with what's known as GERD or acid reflux. By the way, before we even get to what just happened and why, right, the case being dismissed for now, because you'll see how it might come back, you're also going to see there's a difference of opinion about why the case was dismissed. But this is very important to note. This is not the first time we have seen an upheaval in this case. What do I mean? Back in January of this year, the DA's office actually filed a motion to dismiss the case because they wanted to add another charge, this attempted poisoning charge. And there was an issue about an important witness who apparently couldn't show up for the first day of trial, so they dismissed it. So you had a second grand jury who had to be impaneled. They were presented with the evidence, and that's the key there. What happened in the second grand jury has just come back again right now. It is what reportedly happened with that second grand jury that is the reason these charges were now dismissed. And actually, before I even get into that, my colleague, Sierra Gillespie, host Scandal, talked about what happened when the case was first dismissed back in January because of this issue with a witness. I just want to play this for you real quick. Gives you good context as we talk about what just happened.
In the final hour, things kind of get switched up a bit because when a key witness is supposed to testify, their schedule doesn't allow it. Can you explain all of this to me, why the charges would be dismissed if they're just going to be refiled? I mean, would that witness really be that important?
Well, first of all, it sounds like the witness is going to be important. They're a vital witness, so much so that for the time being, what they're going to do is they'll file a motion to dismiss the case. And, you know, each case is different, but typically speaking, you're dealing with a misdemeanor case, you have a certain period of time to bring the case back. If you're dealing with a felony case, you can bring the case back as long as you're not done with the statute of limitations. And so basically, they're going to do the technicality of dismissing the case and then refiling. At least that's what they're saying that they're going to do. Now, meanwhile, back at the ranch, I don't know if there's any conversations going on in the backdrop here where this woman is like, listen, you know, this is ultimately going to be a problem. I don't know that you're going to beat this case, or if any of those discussions happen. So I'm not sure how long it's going to be continued, etc. But I wouldn't be surprised if there were some conversations in the meantime, because they really seem to have her dead to rights. But technically speaking, it's not unusual for a DA, for one reason or another, to dismiss a case for the time being, because you're supposed to answer ready for trial on trial day. So something obviously unfortunate and unforeseen has happened where a key witness can't be a part of it. And so there's a dismissal for the time being, but the case can still be brought back.
And yes, it was brought back. That's what happened. It was refiled. It was presented to a second grand jury. A superseding indictment came out of that. According to the Daily Journal, the second grand jury returned an indictment on the following charges. Count 1, alleged domestic battery resulting in corporal injury between March 1st and June 25th, 2022. 3 poisoning charges, 3 attempted poisoning charges tied to July 11th, 18th, 25th, 2022. And apparently this grand jury, the second grand jury, heard testimony from 9 witnesses, including an FBI chemistry unit chemist, Jason Brewer, Irvine Police Department crime scene investigator, Shannon Goldsmith, Detective John Sanders, and physicians Patricia Tsai and Brian Riff. So now, let's circle back. Now let's go to what we're talking about here. Why was this case thrown out? Why was this case tossed by the court this second time around? What can we expect next? This is where you get a difference of opinion, okay? Now here's the problem, okay? We tried to get a copy of the judge's order, the judge's opinion. We couldn't get it from the court. But what you're going to see, it doesn't affect our analysis because we know how to do this anyway. But what you're going to see is 2 differences of opinions about why this happened, both from the defense and from the prosecution. So Judge Patrick Donahue reportedly dismissed the charges, according to the defense, over allegations that the Orange County DA's office failed to properly disclose evidence during that second grand jury presentation. According to Court TV, the prosecution allegedly withheld from this grand jury the opinion of an FBI chemist who believed that those 3 samples of the substance in question were actually, quote, drinkable and not harmful. That this was apparently based on their pH levels. Could see why that's a big deal, right? Now, Yu's defense team argued that is exculpatory evidence, meaning evidence tending to negate guilt that was withheld from the grand jury, and that could have affected their decision. That it was withheld from the grand jury even after the defense claims, quote, grand jurors specifically asked about Yu's defense. Now, Yu's defense team also argued that the DA's office improperly dismissed 2 grand jurors in front of the remaining jurors, that was prejudicial. Now, to be clear, the Orange County DA's office denies this. In a statement to Court TV, the Orange County District Attorney's Office denied that a failure to present exculpatory evidence was the reason for the dismissal, that they vowed to keep fighting. In their statement, they say, quote, we are refiling this case. We believe in the strength of the evidence in this case and in the professional conduct of our prosecutors. We will continue to litigate this in a court of law as we pursue justice for an individual who is being methodically poisoned by his wife, a licensed medical professional whose intent was to inflict pain on him. As you can imagine, Yu and her defense attorneys, they are thrilled by this. Attorney Scott Simmons, who I mentioned before, of Simmons Wagner LLP, represents Dr. Yu, said, quote, Judge Donahue's ruling reflects the justice system at its best. A court carefully reviewing the record and ensuring that the grand jury process worked the way it is supposed to. For Dr. Yu, this was never been an abstract legal matter. She is a dedicated physician and a mother who has spent 4 years separated from her children, fighting allegations her legal team believes were orchestrated to gain leverage in a divorce and custody proceeding. The human toll of that cannot be overstated. We are proud to have stood by her through this, and we are grateful to Judge Donahue for his thorough and principled analysis. Dr. Yu has maintained her innocence from the beginning. Now she can begin to reclaim what matters most, her family, her patients, and her life. And Simmons added, this is according to Daily Journal, they can obviously refile and will be happy to respond, meaning the prosecution, will bring a motion to dismiss again. Now, Miss Yu, Dr. Yu, had a statement of her own through her attorney. I have spent 4 years watching a life I worked hard to build come apart. I am very grateful that the court looked closely and recognized that the way these charges came about was deeply flawed. The court's ruling allows me to begin moving forward. My focus now is on my family's privacy and healing and on spending meaningful time with my children and nurturing those relationships as we move forward together. According to CNN, Stephen Hittleman, this is Mr. Chen's divorce attorney, said that his client is going to continue to work with the district attorney's office and, in his words, quote, protect his children and himself through the family law court. So different avenue there, civil arena, different than the criminal arena. Okay, my legal opinion on this. If these allegations are true, the defense is right. First of all, why do prosecutors go the grand jury route? You have two options as a prosecutor to get formal charges in a case against a defendant. Two options. You could say, hey, we have enough probable cause, lower standard, enough probable cause to show the defendant committed these crime or crimes and for this case to move forward. You can either go through a grand jury or you can even go through a preliminary hearing. Now, preliminary hearing, it can be trickier for a California prosecutor. Why? Because the defense has an opportunity to be there, to be present, to hear the evidence, to challenge it, to question the witnesses, the prosecution's witnesses. It's open, it's public, and it's the court, the judge, that determines if there's sufficient probable cause. Whereas the grand jury process is different. It is secret. The defense is not present. They don't have an opportunity to put on a case. They don't have an opportunity to challenge the prosecution's evidence or challenge the prosecution's witnesses. It's more one-sided. You just need a majority of the jurors to vote in favor of the indictment. It doesn't have to be unanimous. And by the way, it's a lower standard. It's not proof beyond a reasonable doubt. It's just, is there enough probable cause, sufficient probable cause to support the charges? Now, here is the important part. Despite the fact that the defense does not have a role in the grand jury, prosecutors have an obligation, a legal obligation under California law to tell the grand juries about exculpatory evidence. Again, meaning evidence tending to show the defendant did not commit the crime. Under the California rules, I'll give it to you, I'll read it verbatim. This is California Penal Code section 939.71. If the prosecutor is aware of exculpatory evidence, the prosecutor shall inform the grand jury of its nature and existence. Once the prosecutor has informed the grand jury of exculpatory evidence pursuant to this section, the prosecutor shall inform the grand jury of its duties. If a failure to comply with the provisions of this section results in substantial prejudice, it shall be grounds for dismissal of the portion of the indictment related to that evidence. Now, assuming the defense is accurate, even though the prosecution is denying this happened, assuming the defense is accurate, I think there is certainly a strong argument that by not presenting the opinion of this FBI chemist, that would constitute exculpatory evidence. The idea of the samples, the key evidence here, potentially not being poison, not being poisoning, could be key to jurors analyzing about whether a crime was committed. That's a key element of the charges, is arguably whether or not the liquid was in fact poison, right? Would a jury need to consider this? So the defense can make the argument there's a reasonable probability the grand jurors would have found no probable cause if they heard about that. There's a counter argument to that too, right? The other way to look at it is, well, maybe you allegedly did pour the cleaner, but it wasn't enough. Small doses. Maybe it was a mistake on her part. Does that change the intent? Could still be an attempt charge, could still be a poisoning charge, could still be potentially a battery charge, not sure. I haven't seen the report myself, but you do wonder if that could be explored at a trial. So even if it was presented, maybe the grand jury would say, no, there's still enough here to support the charges. And look, if the prosecution refiles and they go back to a grand jury and they present all of this evidence, so they present the chemist to a new grand jury, who knows? Maybe the grand jury won't indict, maybe they will indict. But again, you don't need a unanimous vote, just a majority of jurors to agree on probable cause, which again is a lower standard than beyond a reasonable doubt. Now, second part, that's one part. The idea that there were jurors that were improperly dismissed in front of other jurors, to me, that's very context specific, because there are times during a jury selection process that you'll see jurors excused in front of other jurors. That's usually due to scheduling or hardship reasons. It's kind of at the beginning, initial stage. Usually dismissal of jurors once they've been selected, that happens outside the presence of other jurors in order to avoid any issues of prejudice or improper influence. And my research, when I did under California law, seems to suggest that a defendant can legally move to set aside an indictment in the case of improperly dismissed jurors if the defendant can show that he or she was denied a substantial right and that the dismissal of these jurors or juror in this fashion might have reasonably affected the outcome of the grand jury. So again, without knowing all the facts or the circumstances regarding this alleged dismissal, you could at least see how this may have created an issue. And if the defense is right, it was enough of an issue for the judge to throw out the case for now. Now, here's the big picture. Okay, this is the big picture, why I think it's not just about this case, but all the cases that we cover. I've said it before, I'll say it again. I know the DA's office is denying what the defense is asserting here, but again, assuming this is true, this is why it's so important to dot all the I's and cross all the T's. Yes, Miss U is innocent until proven guilty. Yes, these are mere allegations. Yes, she hasn't been convicted of anything. But you can see how much effort the DA's office is putting into this. Multiple grand juries being methodical with the case. They didn't want to move forward, apparently, unless they had the right witness. The prosecution doesn't believe this is just a custody dispute or a family dispute or a divorce proceeding dispute, even though that's what the defense will most likely argue at a trial. They believe, the prosecution, they have strong evidence in terms of video, testimonial, potentially scientific evidence, and yet now they're on the defense. They have to go uphill once again. I mean, look, the burden is always theirs. They have the burden to prove beyond a reasonable doubt that the defendant commits a crime. But to now have the case dismissed and have to be presented in front of a third grand jury, I mean, I'm assuming they're going to do that, not the preliminary hearing route. This is costly. This is timely. This takes away their resources. They do not want to have to do this again. So even in cases where you believe the evidence is strong and you believe the defendant is guilty, put Miss U on the side, I'm not even talking about her. In those cases, you have to afford that criminal defendant every right they're entitled to under state and constitutional law. I've said it before. Look with the Kohberger case. Not trying to make a comparison between the Kohberger case and this, but in that case, the evidence was stacked up against him. Cell phone evidence, surveillance evidence, DNA evidence, eyewitness evidence. And I said this on a previous sidebar when it was about change of venue. I said it's actually beneficial to the prosecution. Give him change of venue. Give him the chance to make his motions, because what happens is if you grant that before the trial starts and he's convicted, you're taking away his appellate right. You're taking away his chance to successfully argue that his rights were violated or he wasn't given a fair trial in appeal. If you provide him every opportunity, then it's going to be very, very difficult for a convicted defendant to then say, the case wasn't fair, I didn't have a fair and impartial jury, I wasn't given this opportunity. No. You do everything by the book because you do not want this situation of having to retry a criminal defendant. The last thing you want as a prosecutor is to present all this evidence and go through a grand jury or go through a trial again, and for the conviction to be overturned or the charges thrown out. Besides the time and the resources and how costly this is, what about the family? The family has to relive all this. The witness testimony can change. Evidence can change. So you have to make sure you follow proper procedure. And yes, to be clear, going back to this is currently a win for Dr. Yu, but it does not mean that this case was dismissed on substantive grounds. It's not like the court said, you're innocent, the charges can't be refiled, someone else did this, that's it. No, this is procedural. Once more, there's a different view, different opinion from the prosecution and the defense on why this case has been dismissed and what is going on here. But at the end of the day, this is a dismissal on procedural grounds. Now, I do just want to take a second to talk about the defense in Dr. Yu's case. This isn't a slam dunk case. The idea of her allegedly mixing the Drano with tea or lemonade to attract the ants and kill them, that could be explored at trial. I mean, it's going to be hard to deny, I would imagine, the video itself, if you see her pouring something. I've seen the screenshots. And I do wonder if the children would have to testify and explain, yes, this is what mom did commonly. This is what we all did. The allegation he didn't go to the ER, the allegation that he weaponized this against his wife. There's an argument that there will be a difference of opinion on medical experts on his injuries, his conditions. Is that reasonable doubt? Did he accidentally drink this? Did he make a mistake? Is he now accusing her of doing this on purpose? So if this goes to trial, it will be interesting to see a jury explore these potential issues and narratives, but let's see what the prosecution does next. That's all we have for you right now here on Sidebar, everybody. Thank you so much for joining us, and as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you get your podcasts. You can also check us out on NBC's Peacock as well. If you want to follow me, X, Instagram, my News Nation show, Jesse Weber Live, Monday through Friday, 11 p.m. Eastern. I'll see you next time, everybody.